Digital forensics and incident response. And we'll spend about an hour on some material related to these topics and to have some question and answer at the end of the session. As mentioned before, some continuing education units are coming away if you stick with us until the end of the presentation. So just a quick introduction over on this end. That's me. That's what I do here at New Horizons Computer Learning Centers. Your technical instructor for things like the Computer Hacking Forensic Investigator class, Certified Ethical Hacker. Those are from EC Council. Some of these other things related to investigations, security management. That's what I do. Many years out in the field working in the investigative and auditing side of the business. And I bring that experience into the classroom for classes like the prep classes for the Computer Hacking Forensic Investigator credential, CISSP, and a handful of others. And we will pick a few things from some of those curricula and drop them into the presentation as well. Stick with us as we spend about an hour on these topics, and we've broken it down into 4 general areas. Preparation for forensic response up first, making sure that we have the things that we need to do the investigation properly. We'll talk about the scope of the investigation, make sure we don't overstep our bounds as investigators, and we have to look at some of those distinctions between a civil or corporate type of investigation and a criminal investigation. We'll look at some specific tools of the trade, both hardware and software, and then walk you through the process for capturing and preserving evidence. So quite a bit to cover here in a 1-hour presentation, but we will do our best to get it done within the time that's allowed, and then perhaps guide you to some additional research, some additional study that you could do, whether you are preparing for a certification in this type of subject matter, or just simply want to improve your skill set as a security practitioner. And one of the certifications that is fairly new from our friends at CompTIA, the Computing Technology Industry Association. You may be familiar with their Network Plus, Security Plus, A Plus Technician. They've got a bunch of those, Cloud Plus with the plus on them. And one of their recent credentials that is seeing a lot of interest in, and we're getting some good traction on it, is one called Cybersecurity Analyst Plus. From CompTIA. It's fairly recent, and what I've done here in this slide is borrowed just a little piece of that curriculum that talks about the roles in incident response. If incident response is going to be the emergency management component of security, well, think about what happens in emergency response, perhaps in a medical context. There's an accident, there's an injury, there's somebody who's got to be there to very quickly do a process called triage, but they are not involved from beginning to end in the rehabilitation and recovery of that person who has been injured or who is ill, and there will be others involved in the process. Well, if we're here in an incident response role, in what we will call in the cybersecurity analyst class, what we will call the CSIRT, that's the Computer Security Incident Response Team, we would expect to work under a team leader, perhaps a manager of some type, information security manager, perhaps a network administrator, and some types of organizations could take control of this. Security specialists, help desk staff, the crisis communicator, managing that communication with the outside world so the investigators are not constantly on the phone answering questions. Auditors, legal counsel, various others participate in. And for the purpose of this discussion that we're going to have today, we will assume that you are there actually playing the role of the investigator. You could have been brought into this from outside the organization. If you work as a contractor or a vendor in incident response, you could be an internal employee of the organization, and everything else takes a backseat while the investigation is underway. This could also involve members of law enforcement, and we have to draw this distinction here at the beginning of the presentation. Stay out of legal trouble, please. Do not play police officer if you are not a police officer. And in the play out of the investigation, if you find evidence that a crime has been committed, and we're talking here about an investigation that did not begin as a criminal investigation, if there's simply some security issue that needs to be responded to, if there is perhaps a violation of a corporate security policy, and there you go, dispatched to the scene to begin an investigation. If your investigation there in the corporate environment leads you to the conclusion that a crime has been committed, dead stop. You get law enforcement involved. And we're not saying that you personally would pick up the phone and call the police. In fact, we have to be careful about what level of law enforcement we contact if we believe that criminal behavior has occurred in our organization. So don't put yourself in the position of the police officer without that training. For now, let's assume that they would be available in the appropriate context. If we just call a local emergency or non-emergency phone number, 911, for example, they'll come running. If you dial a non-emergency number for your local police force, you might just get the cop on the beat, just whoever is nearby and close enough to respond in time. And with all due respect to our friends in law enforcement, they may not have had the appropriate training for containing the digital crime scene and preserving digital evidence. They tend to be a little more focused on the blood and bullets and fingerprints types of forensics. So we're going to look at some techniques that you might be able to use in a corporate type of investigation, and we will assume that those in law enforcement would take a similar approach. So talk this over with your corporate legal advisor about your role and what you can get away with and what laws and rules and restrictions you would have to obey in those types of incidents. So in preparation for this forensic response component of incident response, there are some things that you would be expected to know. And the assumption is, if you're working in that capacity, you have probably been a really good technologist. That's how you end up with some of this responsibility for incident response. I know quite a few people who are here in this audience today who have come up through the ranks of help desk, tech support, network administrators, system administrators. You get some responsibility for information security, and then perhaps by default, you become that first responder when there is a cybersecurity incident. So with that in mind, and this assumption that you have a good technical background, you would be expected to know a few things. First of all, knowledge of the hardware that's used within your organization. It is very frustrating in an investigation to run across some unknown or unfamiliar piece of hardware. There is a rather disturbing phenomenon we see these days in a lot of corporate environments, even in some government environments, called shadow IT. And shadow IT happens when somebody decides on their own they need some hardware or software that's not provided by the organization, so they decide simply on their own. Well, you won't buy me this spiffy color laser printer that I want, so I'm going to go buy one myself from the big box electronics store, and we'll set it up. And we just won't tell that system administrator that we have this piece of hardware or this piece of software. It's even trickier when it's software, because you will have employees with the best of intentions simply finding things online, downloading software that might not be appropriate because of licensing issues. There could even be malware in some of those things. And so we have to get a handle on purchasing and procurement and inventory and asset control. Now, wait a minute, Coach, isn't this supposed to be about investigations? Why are you bothering us with procurement and inventory? Well, good forensic response starts with knowing what is already there, knowing what you would expect to find. And again, the context here is in a corporate environment. So you may have been responsible for the rollout of some of that hardware and software. We have to know the tools of the trade, and we will talk about some of those, show you the sources for some commercial tools as well as some open source forensic tools. We have to know our virtualized environments as well, not just local virtualization like you might do with VMware, VirtualBox, Hyper-V, but also the way things get virtualized in cloud computing environments, virtualized applications that can be run in a variety of platforms. The forensic analysis is a lot easier when we're simply running local applications in operating systems on local hardware. It's a little trickier when this is in the cloud or in some other type of virtualization. We have to know which systems will stay active during an investigation. If we're doing a device seizure involving a desktop PC, for example, and we are called to the scene, we do the device seizure. The ultimate goal is to copy the hard drive and do this bit for bit analysis of that. Well, that's fine. If we lose one laptop, one desktop PC, that will simply not be in the network for the amount of time that it takes to copy data out of that. But what if it's a router? What if it's a server? What if it is some significant piece of infrastructure? This is where it gets tricky, because this will now affect the entire network. What if the clues are actually in the flash memory or in the firmware on a network printer, copy, or scanner fax machine? Can the organization be without that product for the amount of time that it takes to capture that evidence? We have to ensure that there is policy in place and that you're actually following the policies. So this takes some setup with your corporate legal advisors and other practitioners. And of course, we have to know laws and regulations appropriate to forensic response. Everything that we do in incident response can be in danger, and our ability to prosecute somebody who has committed a cyber crime or some other type of crime, or the ability to do this administrative smackdown on somebody who has clearly violated some type of corporate security policy, all of that can be in danger if we break the law even accidentally during the course of the investigation. So get some good legal advice on this. And we have to understand the nature of evidence. If the whole point of forensic response is the capture of evidence using some good scientific methods that might be used in a civil or criminal or corporate type of investigation, we have to know that different legal rules could apply. So let's just get a good basic definition. Evidence will be something that tends to establish or disprove a fact. The theory of the crime, perhaps, could be supported by evidence. We could also reject a certain theory of the crime because of evidence. And we would expect that if you ever have to present any of this stuff in a court of law or do a similar process in a corporate type of enforcement, 4 different types of evidence could be presented. And we'll take the courtroom perspective on this for this discussion. Real evidence will be something that you can actually take into court and present to a jury. So if it's a corporate type of administrative process, what would be the equivalent of the jury? Perhaps a board of directors, perhaps some type of administration. So in any case, real evidence will be the most powerful type of evidence. It typically speaks for itself. In a more traditional forensic context, if somebody has been injured or worse because they were shot, well, the actual weapon being brought into court, sealed up in a bag, obviously, and shown to the jury and shown to the judge, this is the weapon that was used in the commission of this violent crime. And we recovered these bullets that we were able to prove through a forensic process, ballistics, were fired from this weapon. This is very powerful evidence that tends to speak for itself. If the very idea that somebody was shot is in dispute, producing a medical examiner's report, producing the actual weapon, producing the bullets, tends to at least prove the case that the injury did occur. This would be considered real evidence. So put this in an IT context. If we're responding to a cybersecurity type of incident that may have been committed off of a smartphone or a tablet or a laptop computer, actually presenting the device itself, which may have some biological evidence like fingerprints, DNA, and so forth, as well as the digital evidence. Certainly this would be considered real evidence. Another type of evidence that we might be a little more connected with as IT practitioners would be documentary evidence, usually in written form. We could do some of this in electronic form. Written form does not always mean signatures on paper, but even in electronic form, documentary evidence could be things like server logs, emails, spreadsheets, files from databases, web pages, all of these that would be considered part of your modern IT environment. They could be offered as documentary evidence, but we have to be careful. Some of this documentary evidence could be faked by somebody who knows the application well enough that would have produced the evidence. So somebody who knows their way around the email system could fake the identity of somebody, send that naughty email, or even fake the email itself. If we're just looking at a printout of an email, how do we know that that's genuine? If there's a server log that's introduced into documentary evidence, we would hope to have some procedure that can prove the authenticity of that evidence. Some precautions have been taken to ensure that nothing was added, nothing was taken away, and you are looking at a true reflection of the original evidence. But that would be considered documentary evidence. It is not real evidence. Another possibility is testimonial evidence, usually the statement of a witness under oath or some type of affirmation. These things could be delivered in court, maybe recorded in a deposition where you go to an attorney's office and they've got video and audio recordings of somebody giving their testimony. So this typically validates or supports the other type of evidence for either proving or disproving the bank was robbed, and a testimonial could be given that I saw that guy rob the bank. I'm pretty sure it was him because of these characteristics. Well, somebody else could come in and say, well, I swear under oath that this is not the person who robbed the bank. You've got the wrong guy because I saw somebody else who had this different look, this different characteristic. And so we get to toss these things around in court. And there are ways to prove or disprove based on testimonial evidence. It's not likely that you, as the first responder doing a forensic practice, would generally testify in court on those specific issues. You might be called upon to give either technical witness testimony or expert testimony, as we will talk about here in just a bit. Another possibility for this delivery of evidence is called demonstrative evidence, explains or recreates some other evidence. So this is evidence that does not speak for itself, but it helps somebody to understand the meaning of the evidence. And maybe even a technical topic could be presented to a non-technical audience. Well, in this case, the non-technical audience might be the jury. It might be a panel of management and administrative personnel in your organization who want to know how something happened. How did we get hacked? How was there a data breach? How did this employee get away with stealing something of value from our information system? So you could set up demonstrative evidence in a set of virtual machines and actually demonstrate a hacking attack, demonstrate a SQL injection, a type of attack against a database where you simply recreate the activity of the hacker. And now that audience has a better understanding of how this stuff could have been done. There is a best evidence rule that we tend to use over on the federal side. There's a set of standards called the Federal Rules of Evidence. And not all courts must obey federal rules of evidence. We tend to use federal rules of evidence as a baseline standard. And a city court, a county court, a state court, something smaller than federal jurisdiction, certainly could use standards of evidence that are stronger than federal rules of evidence. They generally do not get any weaker than federal rule of evidence. So the feds say, and we agree, that evidence presented in court should be original. If there is the true, authentic piece of evidence available, let's present that. If there's a dispute about a contract in some civil law matter, and the two participants in the contract disagree about something, it would be great if we could actually present the original contract, not a copy of it, but the real thing. I want to see signatures on paper. I want to see the paper itself. I want to see the ink. I want to see any wear and tear on those pages, because you might notice something a little unusual. One page of this contract doesn't appear to have the same ink, doesn't appear to be the same age, does not appear to be from the original document. Now the whole thing is called into question based on best evidence. Well, we don't always have best evidence in a forensic context in your IT environment. And so there's some case law on the books, and federal rules of evidence will agree with us, that if we do a proper bit for bit forensic image of a hard drive of a computer, that could in fact be considered best evidence, if and only if we can prove that it is an identical copy. So today we will talk about some of the ways that we can actually get that done. One of the key pieces of advice for the practitioner who may get involved in this is to be aware of those federal rules of evidence. If you take the computer hacking forensic investigator class with us, we actually beat you over the head with these things called federal rules of evidence. You do have to know some of them in a little bit of detail. So probably the best simple way to get familiar with these federal rules of evidence, really easy to navigate website maintained by Cornell University Law School. So there is the URL down at the bottom. And the things that affect us really as the cybersecurity practitioners doing the forensic analysis would be in those things like Rule 1002 and Rule 1003 about requirements of original evidence versus the possibility that we could introduce a duplicate if we can prove that it's identical to the real thing. Well, how do we get this evidence? Do we just walk up to somebody's desk or a cubicle or stop somebody in the hall to say, may I see your laptop, please? Can I see your company-owned smartphone? What if it's a personal smartphone? We have to be careful with search and seizure. And anybody who's doing this on behalf of government, typically because a criminal investigation is underway, has to be very, very careful not to violate Fourth Amendment rights. This is part of the Bill of Rights. It's built into the United States Constitution. And if the police department or some other person acting on behalf of government doesn't do this correctly, we've got some serious issues. The entire case can be thrown out if we do not have proper procedure followed by police departments. The presumption of innocence is not optional. We always have to assume innocent until proven guilty. And so some paperwork signed off on by a judge or magistrate or somebody with some similar authority would specify the thing that will be seized in the very specific circumstances in which law enforcement can take something into evidence. Now, they don't always have to have these search warrants because in some cases, if we simply get consent, there is the form that's used by the Secret Service where you can voluntarily allow them to do a device seizure or seizure of something containing some bit of information that might be helpful or useful in an investigation. So this rules against illegal search and seizure can be worked around if somebody can actually get the suspect or some other interested party to give up the right to be bound by that Fourth Amendment. So this gets tricky. Talk this over with your legal advisors about what's the appropriate thing to do in a criminal investigation. Over on the corporate side, what we would consider a private investigation or a corporate investigation that you're probably much more likely to be involved in as an information security practitioner, if these types of investigations are not conducted by government because we have no reason to believe a crime has been committed, then we are not bound by those Fourth Amendment issues. Usually these are violations of security policy. We're trying to correct the user behavior. If it's bad enough, it might actually lead to the dismissal of an employee. So we do have to proceed with caution. Because what if we make the wrong determination here? We believe that somebody is involved with fraud or espionage. They're stealing something from the company. They're doing some awful thing, basically, from their workstation that you have given them to get their job done. If we don't get this right, and that person is fired because of something we thought was the truth in our investigation, that's going to come back on us in a very bad way. There could be some very unpleasant legal issues associated with that. So before we begin even the process of search and seizure, let's make sure we have the approval and the guidance of senior management and your legal advisors. Depending upon what business you're in, we don't really expect senior management to be aware of the legal issues. That's what the legal advisor is for. We don't expect them to really be aware of the technical issues. That's our job. But getting senior management to sign off on the process, give you the scope and charter, basically, of that activity is very important. So have these discussions with legal advisors and your corporate practitioners before you need that advice. Let's talk about the scope of the investigation. This is critical because in the conduct of the investigation, you might find the need to hand something over to law enforcement. You might accidentally overstep your bounds in an investigation. Well, let's assume that there is a goal in mind, and that is getting admissible computer-based evidence of a crime, a computer security policy violation, or some similar incident. Don't play cop if you are not a cop, obviously. But the key here is admissibility. You can do all the right things scientifically, forensically, going through processes of making identical copies of things and drawing the appropriate conclusions. But if this is presented in court improperly, you may have that evidence tossed aside. The judge in that case generally has the right to say, I will allow it or I will not allow it. And once the judge says the magic words, I will not allow it, that's it. Any conclusions that you could have rendered from that evidence are not invalid, but just not to be considered at that point. And you may be back to looking for additional pieces of evidence. It's far too late to do that once a trial is underway. Evidence might be located in a variety of devices. The company-owned workstation, a laptop, desktop, tablet, smartphone, those devices could be owned by a private citizen, could be owned by some element of government, could be owned by your corporation. Peripheral devices, mobile devices, even the network itself could actually be the source of some evidence. And so there's a fundamental principle that we have to assume always. We're going to work from a copy of the data rather than the original source, if it is possible to do that. And now there may be some circumstances in which time is of the essence. Imagine an incident in which a smartphone has the evidence. There were text messages, there were various other things, something seen by the camera of that smartphone, a call has been made, something in the small web browser in that smartphone, and we expect that we will not be able to get that evidence in its entirety if the phone goes off. It's running on battery power and you don't have the charger. Whoops, we find the orphan smartphone basically with no way to power the phone. If we don't have the adapter that's necessary, if we don't have a way to get a fresh battery into the thing, we may actually lose some evidence. Now, there could be perishable evidence there. There could also be some more persistent evidence, and we'll talk about that in section 4. But in any case, you may find yourself in these instances where time is critical and you have to work from the original evidence. Most of the time, that's not the case. If we are well prepared, we'd be able to make an exact bit for bit copy of the evidence. In this case, we're thinking about things in the typical computer hard drive. So there are forensic software packages, both commercial and open source utilities, that would give you some options for doing that. And we'll show you some examples of that software. Well, if there's data in, let's say, the hard drive of a desktop PC, a server, a laptop, if we're talking about traditional hard drive technologies, don't we have backup utilities that could do that? Even a simple consumer grade backup utility where we back up to a partition on the drive, back up to a USB drive, back up to the cloud, Dropbox type of service. Well, that's okay for saving copies of data, but what you do not get is a forensically pure copy of the data. And if it's not forensically pure, if we can't determine nothing was added, nothing was changed, nothing was taken away, nothing was altered, then this evidence will not be admissible. A backup utility would be better than nothing, but just barely better than nothing, because we generally do not get to introduce that as forensically pure evidence. We need to avoid using any process that would actually write information to the suspect's hard drive. So if we use a backup utility, well, this implies that as an administrator, you get in and you click a few things with a mouse and you type in a few things, and a few keystrokes later, you're running a backup, but you've actually interacted with the machine at that point. Timestamps will be generated. If it's a Windows box, registry entries would be generated by that process. Your simple presence in the system doing a backup will actually change the nature of the evidence. If we find a Windows PC, and this is true of Linux and Mac and Unix as well, and even your portable formats. But in the classic Windows box, if we boot into Windows to run a backup, even if we add no other data to the system, we will still see an alteration of timestamps, log entries. There will be various clues left behind. So now at that point, we're not dealing with the original evidence anymore. We're dealing with the evidence plus the presence of the investigator. And we have made an awful mistake at that point if you actually engage with the operating system anyway. If we simply copy files from the target computer, we'll get some things that might be helpful, but we're not going to get the things that are invisible to the operating system. And a key term here is slack space. Little bits and pieces of files that may have been left over by a process that could be put back together. In fact, if somebody believes that their system is clean, there was this incriminating evidence, says the criminal, says the hacker, I'm going to delete these files, I'm going to drag them over to the recycle bin in Windows, and I'm going to empty that recycle bin, and now this naughty evidence is going to go away, and nobody will figure out that I did this. Well, that doesn't actually make the file go away. In a Windows environment, you've simply changed the index information of the file. The original data is still there, probably right where you left it. And over time, some of those areas of the drive can get overwritten. But there are some techniques to get those allegedly deleted files back in their entirety if we can get to this system in time. So the operating system doesn't always know what's on the drive. The operating system can only show you things that obey the normal rules of indexing and arranging the drive. We have to be aware of a principle that predates the cybersecurity investigation by a very, very long time. One of my heroes in the business, and I would like to have known this man, but I was born too late and he was gone too early. Dr. Locard lived in a chunk of the 19th century and a big chunk of the 20th century. And he left us with Locard's exchange principle. So there you see it. Wherever he steps, whatever he touches, whatever he leaves, even unconsciously, serves as a silent witness against him. The language here is definitely 20th century language, but you get the general point on Locard's exchange principle. He was a brilliant criminologist, and what he left us with as his primary principle is, when you visit the crime scene, you will always take something with you when you leave, and you will always leave something of yourself behind. So whoever initially did whatever the crime is has left something behind. There is biological forensic evidence, there's physical forensic evidence, and if we can capture that evidence without disturbing the crime scene, we have a really good chance to solve the crime, prosecute the criminal. Done deal. But here's the problem. Our presence in the crime scene changes the crime scene. We have to be extremely careful about handling things and leaving biological evidence of our own behind. We will always disturb the crime scene, whether we need to or intend to or not. And the more people who are involved in the investigation, the more likely it is that the crime scene gets disturbed to the point that the evidence is no longer trustworthy. So take this 20th century principle of Locard and apply it to your modern information systems. The more hands we have on the keyboard and the mouse, the more people who are involved in the capture of evidence, and the longer we spend in the place where the evidence is captured, the more likely we are to even accidentally do something that changes the nature of the evidence. So we have to be very careful. We use right blocking technologies. We go through some steps recommended by the manufacturers of our forensic software to make sure nothing gets added, nothing gets taken away, and we can actually generate pure bit-for-bit copies. So in incident response, our role here is the role of the first responder. Incident response happens before the actual forensic analysis begins. If you are the person who is going to go through that set of experiments on the evidence, if you're going to do the very detailed examination of multiple bit-for-bit copies of evidence, you might not actually be the person who seized the evidence and brought it to the laboratory. In some cases, especially in organizations that are not fully staffed for incident response, one forensic specialist might do everything. You're the first responder gathering the evidence, as well as you are the forensic examiner doing the investigation of the evidence. Bigger companies, well-staffed elements of government, state police organizations, FBI obviously will have different staffs for doing these things. And this may even involve a handoff of evidence from one agency to another, or from your company to some element of law enforcement. So in this first response, which might be your responsibility, we secure, we preserve, and we document the evidence. That incident responder may not necessarily be the actual forensic specialist doing the full analysis. So if this stuff happens in your corporate environment, who does the incident response? Usually it's a technologist, a technician of some type, perhaps an administrator with some information security responsibility. If your position in your organization is anywhere near equivalent to an information security manager, you are probably a first responder for these types of incidents. If your organization does not split the responsibility of information security and information technology, so perhaps you're just that alpha technologist who is a network administrator or a systems administrator or some type of director of a technical service, you might be that first responder, and you might or might not have personnel working with you in that capacity. If it's a criminal investigation, usually a law enforcement officer, perhaps a crime lab technician, will handle some components of incident response. And that's why we say go to the highest level of law enforcement. That would make sense. With all due respect to the hardworking men and women of law enforcement, as they say on Cops, probably one of your favorite shows, they're busy. They are in a very stressful occupation. They are on the move constantly, and they may not have had the appropriate training to contain the digital crime scene. It is a matter of specialized training that the officer on the beat sometimes just does not get through no fault of their own. So we get specialists involved in this. That specialists might be you with the appropriate training. And here's the scary thing. It's not unusual for police to be called after corporate personnel have accidentally compromised the crime scene. Very frustrating to have a member of a corporate environment who really means well going through somebody else's workstation looking for some type of clues, and there's actual criminal behavior there, and we've ruined the evidence. So careful, please. Let's remember no cards exchange principle. Always. You always leave something of yourself at the crime scene, and you always take something away, whether you intend to or not. So who's got some good advice on this besides CompTIA and EC Council and the folks who put your courseware together? Let's start with the feds. The Department of Justice and the National Institute of Standards and Technology have published two of these fundamental resources. We use these documents all the time in classes like Computer Hacking Forensic Investigator, Security Plus, CISSP, some of the others that involve some forensic content. The Justice Department is on it. They have written this document called Electronic Crime Scene Investigation Guide for First Responders. Over at the Commerce Department, that's where you find NIST, National Institute of Standards and Technology. They have published a great document on this called The Guide to Integrating Forensic Techniques into Incident Response. And these references are updated every now and then. So first of all, we will trust our own feds here in the United States. We also realize that there may be an international approach to all of this that could make sense. We may even have some international participants in our webcast today. So we will look to an additional source of authority. Love these folks. They are so generous with some of the stuff that they have put into the public domain for people like us who need to know good practices. And so this is the Good Practice Guide for Computer-Based Electronic Evidence. This is from the Association of Chief Police Officers in the UK. And so this is written from the perspective of British law rather than American law, but there's a lot of concepts here that would make sense. So first of all, they say no action taken by law enforcement agencies or their agents should change data held on a computer or any storage media if we expect that we're going to have to rely on this stuff in court. That makes sense. We're making these precautions to make sure nothing gets added, nothing gets taken away, nothing compromises the integrity of evidence. And there may be exceptional circumstances where you have to access original data. So whoever does that has to be competent to do that type of investigation. So that's the phenomenon I described earlier, this kind of bizarre scenario where maybe there's evidence on a mobile device and the battery is running down on that mobile device. You don't have the charger, you don't have the adapter, you don't have any way to power the device right there at the scene of the crime. And we expect that we may lose some evidence unless we can directly interact with the device. And so those things should happen on rare occasions. That's not the normal procedure. An audit trail or other record of all these processes should be created and preserved, and an independent third party should be able to look at those processes and get the same result. So if you and I are equally talented digital forensic investigators, I can look at your results, you can look at my results, and see, do these things match? You could use a well-accepted forensic tool, and I could use a totally different forensic tool that's also well-known and well-accepted. And if we're looking at the same evidence and we're using the same scientifically valid process, we should reach the same results, regardless of what tools we're using. And over on the UK side, they also say the person in charge of the investigation has the overall responsibility for ensuring that the law and these principles are adhered to. So that might be an information security manager, might be a more specialized type of discipline. So look at some basic steps as you are called to the scene of the incident. Be prepared to do these things. We photograph and we record video of the computer itself, the surrounding area, before you unplug any cables or power cords. The typical rookie mistake is recording video and taking high-resolution photographs with your own smartphone. That would generally be thrown out because the connection to the internet and the connection to the cell phone network might introduce some doubt. Well, it's possible that that evidence was changed simply because of those network connections. So actually use specialized devices, just standalone still and video cameras for photographing the area. Photograph any data that's on the monitor. Actually draw a detailed diagram of peripherals and how they connect to the PCs. Don't unplug anything until you actually have those things labeled and photographed. You'll document connections to network servers, even off-site storage like in cloud computing. Look for other evidence nearby, notes containing passwords, URLs, any references nearby, computer books, manuals, software packaging, anything that would help put this thing into context, determine how the computer was used. And you have to determine the time of last access to the computer itself. And this is critical that we establish a timeline of activity. In some forensic software, this stuff is done automatically. You might even just use a spreadsheet application to do your timeline analysis. And so as we're looking at things that have been seen in that system after making the bit-for-bit copies, you notice that highlighted item, LOIC, whatever that is, and that was a zip file. Apparently an application was seen and perhaps downloaded, perhaps used. And a little research shows us that LOIC is the low orbit ion cannon. This is one of the classic script kiddie utilities for denial of service. Whoops. That's not supposed to happen in your corporate environments. People should not be able to download potentially destructive utilities. Well, clearly something's up here. And now what we don't know is who actually did this. We might start certainly with the identity of the person who was logged into the system at the time, but we have to be very careful with the attribution. If somebody's downloaded a utility whose sole purpose is disrupting the network, a federal crime may have been committed, depending upon the context. We have to be very careful about blaming the user of that workstation. That is one and only one piece of evidence that might actually lead us to that conclusion. And when the user of that workstation says, well, no, I wasn't here, look at the time, 13:13, that's 13 minutes after 1 o'clock, and I take lunch every day, same lunch break between 1 and 2 local time every day. I am absolutely not at my workstation, and I can prove I'm not at my workstation because I have eyewitness testimony. I have my receipt from the point of sale system in the company cafeteria. We've got video surveillance. We've got all of these things that lead to the conclusion that user was not at that workstation that day, that time. Now we've got some bigger issues. We've got somebody getting on that person's workstation, perhaps to deflect the blame from their own malicious activities. So this could get quite complicated, and this will all be dependent upon timeline analysis. If we don't know exactly what time it is outside the box, then we're going to have some difficulty making this stick. And so a critical thing you see here in the middle of this slide is recording the time offset. Among other things that need to be captured in the analysis of the compromised system, I need to know exactly what time does this computer think it is. A laptop, desktop, smartphone, tablet, router, server, they all have some internal timekeeping, and we have to get the difference between that internal time and the actual time out here in the real world, because that might enhance or degrade our ability to nail something down to a specific time as you compare these things to network traffic and logs, other things going on in the network. So we will capture the system image with a variety of tools. That's that bit-for-bit copy. A lot of times the forensic software, if it's good, will nag you about that, taking hashes these little mathematical calculations to simply validate and verify that nothing was added, nothing was taken away from some piece of evidence. You'll do that frequently in your forensic examinations. Simple utilities will get that done for you. We take screenshots, we identify witnesses, we track hours and expense so we can properly pay the people who do this type of work. This is not an 8 to 5 Monday through Friday type of process. In many cases, there's some very long hours and some unusual expenses involved. We have to maintain chain of custody. This is all about integrity of the evidence. We cannot take a chance on exposing that evidence to something that could change the evidence. So from the collection of the evidence to the analysis and storage and ultimately presentation in court of some evidence, we will maintain very detailed records. And we actually want signatures on paper. This is not just in electronic form. You really do want signatures. You want timestamps. You want validation that more than one person was involved in this and there was a proper handoff of evidence. So if you are that sole forensic investigator working on something, you would hand that evidence off at the end of the business day to somebody who is now responsible for securing it. We don't just lock these things up in a desk drawer somewhere and walk away from them. And then when the investigation begins again, perhaps the next business day, that custodian of evidence hands the evidence back to you and you get signatures and make sure that these things can be traced. Chain of custody is going to answer some very important questions. Where's the evidence been? Who had access to it? What's been done to the evidence? Has it been left unattended? This is a deal breaker. Unattended forensic evidence. I just locked it up in my desk drawer, went home, unlocked it, and continued the investigation the next day. Game over. There could have been a circumstance, not likely, but it's possible somebody got to that evidence if we did not put it in the hands of a custodian of evidence. So again, this is about very detailed record keeping about who's had access to the evidence and could it have been subject to tampering. So we take the appropriate care and caution in logs with case numbers, item numbers, details of who had access, date, time, all of those things, and even hash values if it is digital evidence. So we would expect that you work with some software that will either automate some of these processes or just give you a good scientific basis for doing a manual version of the investigation. And you'll actually use some of these tools in different places, so they will be different tools depending upon what part of the job is getting done. The incident response tools will be the things that are with you, hardware, software, various other components, as you respond to the incident. They may not be the same tools that you use from the beginning to the end of the investigation, because there will be some laboratory tools where we do this very detailed analysis under controlled conditions. Again, depending upon staffing levels and budget, you might be the person who uses both of these. They'll just be used in different places at different times. So, some essential hardware. Typically, we're working from laptops for data acquisition. There are some specialized utilities that could be thrown in, like write blockers. Want to make sure that there is no chance that you actually engage with that operating system on any device that is being seized. You want to force a condition where it's impossible to even write a bit of data to that drive. We will copy some data onto external hard drives, USB-powered drives, for example. Even thumb drives could come in handy. We have to be concerned with physical issues as well. Make sure that we're properly packaging evidence. So there will be evidence bags, identification labels, evidence inventory logs that have to be filled out on site. Even something as simple as latex gloves or some other type of gloves, just to make sure we're not leaving any fingerprints behind. You don't ever want to do anything that would interfere with the more traditional blood and bullets and fingerprints component of an investigation. And if there are those more traditional forensic practitioners there, you have to simply agree with them that you will not disturb their evidence. They will not disturb your evidence. A variety of hand tools. And of course, you need to be able to take photographs and video of the scene of the incident. Some of your vendors make this easy by bundling the tools. There's a product available from our friends at Paraben that's called the First Responder Bundle. A lot of the hardware that's used in that type of context. They also have the Stronghold bag. This is a version of a Faraday cage if the investigation involves a mobile device. So there's a smartphone, a tablet, maybe a laptop. If we assume, especially in something like a smartphone, that the perpetrator may try to reach out across the network and send a signal to that smartphone that would either delete some evidence or disturb the state of the evidence. We cannot let that happen. So you'll put those wireless devices in containers that are specifically designed to isolate the device. So the remote wipe of the device, which might be done to eliminate some evidence, should not be possible if that's in a good Faraday container. Once we get the equipment, hard drives, and so forth, even a full desktop PC, we get those things back to the lab. You will typically work from a forensic workstation. This is not consumer level gear. This is expensive and worth it if you get a well-designed forensic workstation. This is about putting the appropriate processing power and memory into place to run the forensic analysis software. And we're really concerned about the ability to swap things in and out. There will be multiple kind of non-standard pieces of hardware that you would not see in a typical desktop PC to make it easier to move hard drives and USB-powered components and other things into and out of that workstation. Your forensic software will assist you in a variety of techniques like disk imaging, the recovery of data, checking integrity of the data through hash values, even cracking passwords and doing some other things that might let you into some encrypted things on the drive. We have both commercial and open source software. In any case, we're going to use the software for typically copying data from the suspect's drive or some other source of data to an image file, and then we analyze the image from the image file. Rarely, if ever, would you do the analysis on the original data. So we have some well-known commercial utilities. The good news is that they tend to be well trusted. If you have to take these things into a presentation in court, you generally get dedicated technical support. Some of those utilities may be expensive, and you have some licensing issues as well. You may even have to be a member of a restricted group of customers like law enforcement for certain utilities. It's a well-known commercial utility called Encase Forensic. This is good stuff. I've used Encase many times over the years. We do this in actually some of our classes. The Computer Hacking Forensic Investigator class has some activities with a specially licensed version of Encase. There's the Forensic Toolkit from Access Data. What you're going to see here are some screenshots from an activity that we do in the EC Council Forensics class, Computer Hacking Forensic Investigator, where we're going in and doing some analysis on a pre-captured image file. There you see it, the raw image in the DD format from Linux, which will give you an exact copy of something. Nothing was added, nothing was taken away. We validate and verify that with hash values. And then you get to drill in and see detail in that data that was captured. The metadata, detail about the data, all of this is extremely important. And this is all going to work beautifully if we can validate and verify that the evidence is authentic. If there is any doubt about what we're looking at, something was changed, something was added to, something was taken from that evidence, there goes the investigation. So a well-written forensic tool will generally give you those options for the preservation of the evidence. There are some open source forensic software as well, where you generally don't have the unpleasant licensing issues. Those tools tend to be free. In some of our labs and our classes, we use the Sleuth Kit and the autopsy graphical user interface that goes on top of the Sleuth Kit. Great tool for free, delivers some great results. There's another one that's a full-featured Linux distribution called Kane, the Computer Forensics Linux Live distro. This is good stuff, and it's free, and it's awesome. There are some disadvantages of open source software, however. You could end up with limited vendor support. A lot of times you're in the command line interface rather than a comfortable and familiar graphical user interface. Good example of how we have to deal with the rate of change in some of this stuff. For many years in our labs and class, we've used the digital forensics framework. It was a great tool, but it's gone. The developer has pulled the plug on the product, and it is no longer available. So who's keeping an eye on the quality of software? That's our feds. NIST, the National Institute of Standards and Technology, give us some ways that we can validate that the software itself is good. And when NIST signs off on some forensic software and some forensic techniques, we generally trust them. Whether we use commercial or open source software, these things should be accepted by law enforcement, security professionals, the legal community, should be fully functional even from portable computing platforms, getting images files in multiple platform formats and making efficient use of storage. We're looking for those things always in our forensic utilities. Here in our final section, before we send you on your way, let's talk just a little bit about the handling of digital evidence. The Scientific Working Group on Digital Evidence at that address has some good guidance for you on the things that we do in the forensic process. What do we do when we find a system powered off versus what do we do when we find a system powered on? How do we handle the various components? And so their advice boils down to this. Each link of the chain of custody has to ensure that the evidence remains unaltered. We're using procedures and processes that are standardized and repeatable. We want to work from evidence that is as undisturbed as possible. We're always doing these investigations with the integrity of the data in mind, because if we ever have to go to court with any of this stuff, there will be doubt thrown in by the opposing legal counsel. We don't hold it against them. We don't take that personally. That's their job, to call doubt into the process. So we have to be able to answer questions like, how did we copy the evidence? How did we protect it? Has there been a change to the original data in any way? And how are we certain that those conditions are true? If we say, I don't know, to any of those questions, then that evidence might be ruled inadmissible. So we see some practices for collecting volatile data. That's things in memory, basically the things that will be most likely to change. And then once we have collected volatile data, you can go to the processes for collecting more persistent data. Here's a beautiful tool when used as intended. This is the Coffee Kit from Microsoft. They're very careful about who they give this utility to. The National White Collar Crime Center and Interpol are now involved in the distribution of this. It's a free utility that can be used to capture a lot of that volatile data. Usually it's limited to law enforcement and similar practitioners. The persistent data is the opposite of the volatile data. It's what's going to remain in something like a hard drive or some other storage media after you actually power down the system. The collection process can render the data useless or inadmissible if we are sloppy, if we don't use good scientific procedures. So no matter how we capture the data, it's vital that we hash it. We run a mathematical process on it to verify the integrity of that data. And that's got to be a repeatable process. So to actually get that data off of the drive, we're not really taking it off, we're simply duplicating it. There's a variety of ways to do this, and your forensic toolkits usually have the appropriate hardware and software for that. We can even do the disk imaging on a dedicated forensic system back in a lab environment that'll have all the necessary hardware and software for those bit-for-bit copies. Out in the field, you might have to do a system-to-system image or even a disk-based image. This can be kind of slow. It's kind of difficult. With all of the distractions that are possible out in the field, you really have to watch those systems. A lot can go wrong. We can do a disk image on the original system where you use the suspect's computer to do the image transfer itself. An on-the-scene incident response where you simply do not have time or it's not practical to transport a machine to the investigator's laboratory. This is where you will enforce write blocking through a USB drive, CD-ROMs, DVDs to capture that image. We have to make sure that in the lab environment, if we use a forensic workstation, it does not connect to the internet, does not connect to any computer outside of a secure network. You wouldn't check your email or do your web surfing on that forensic machine. If there's evidence on removable media, we can generally zip up multiple images to be stored in your forensic workstations. In any case, you want to make sure that you handle the original source material as little as possible. There is a file carving approach that helps to recover data that may have been partially deleted and doesn't have any metadata associated with it. Your forensic utilities like Encase and the Forensic Toolkit are quite good at that. Ultimately, we have to preserve evidence with the expectation that these things could be presented in court. Even if we don't have a criminal or civil type of proceeding in mind at the beginning of the investigation, this could turn depending upon what kind of evidence is found. So we take steps to preserve the evidence all the way down to good physical security of the facility where the evidence is housed. My friends, let me leave you with this one conclusion, and then we will gladly take some questions. Admissibility is our key concept. We have to assume that some of this stuff could end up in court, and we have to think ahead to what might cause a judge to say, I will not allow this evidence. Did we have proper search warrants or the proper corporate authority? If we don't have those things, we might be accused of an illegal or inappropriate seizure. We certainly do not boot up a computer operating system and go poking around for evidence. You'll let your software do the mathematical heavy lifting of capturing bit for bit content and then examining the copies. And we never violate chain of custody, because if we do that, we're going to have some doubts about who actually had access to the evidence. Who's got some good guidance on these issues of admissibility? Guess who? The feds, the Justice Department specifically. Go looking for this. It's a great little document called Digital Evidence in the Courtroom. And it is one of those documents that we always distribute in any of our information security classes that have any discussion of forensics. Great little document about what you would expect if you're ever involved in this in any way that might be done in a court of law. So it is fascinating reading. I do recommend that you look that one up and spend a little time with that document. All right, my friends, we have reached the end of the time that is available for this part of this activity. And Jesse, if you are with me, I'm going to turn it over to you for just a bit and work through just a few slides here at the end of the presentation.
Yeah, if you want to take a look at the questions that are flagged, I flagged for you. You can get those in ready for the question and answer session. But I did want to let you all know that we are here to continually provide you content. We have breaking industry news on our social channels, such as the latest viruses, hacks, and more information. There's also tips and tricks in cybersecurity and more that we offer, as well as the future free webinar announcements and reminders, and latest product certification and version updates. So there's a lot to keep in touch with us on. Dennis, you can go to the next slide. These are samples of our social media right here. And you can visit our Facebook, LinkedIn, Twitter, and Instagram. They all post pretty much the same thing, whatever your social media preference is. It's usually at NH Learning Group, except for Facebook and LinkedIn are those URLs right there. So we invite you to connect with us to stay in the know, keep in the loop, so that, you know, obviously you're not just getting emails, but you're ahead of the curve with the latest information. I also would like to invite you to our survey. It is not required, it is optional, but we do hope that you're able to take that survey and help provide us with some information to keep these presentations the best possible. I also dropped the link in the chat box so you can click to it right now, or at your convenience. We'll also email this out. And so I'll pass it back to Dennis to answer any questions that are in the chat box as we wrap this up.